Thank you very much.
Madam Chairman and members of the committee, thank you very much for the opportunity to speak with you today. Senate Bill 141 is important to the business community, and I'm honored to be here to help you shed some light on why.
Okay, you want to state your name for the record and where you're from?
Alfredo Ortiz, Roswell, Georgia.
Okay. Your Job Creators Network?
Yes, ma'am.
And what is that?
Job Creators Network, which will be my testimony, is the voice
okay,
of...
go ahead.
Okay.
I can't ask too many questions.
No, that's okay. The Job Creators Network is the voice of real job creators that has been missing from the American debate on jobs and our economic crisis. JCN members talk about paychecks and not politics, helping the public and policymakers understand how to create jobs. Okay. Any other questions?
No, go ahead. Go ahead.
JCN is also a nonpartisan, nonprofit organization and depends solely on the contributions of individuals, corporations, and foundations who receive no government funds. Our members are CEOs and presidents of small to medium-sized enterprises. Some are large company founders who once led a small business. Our members are greatly concerned about healthcare reform, and they recognize the present malpractice regime as a significant driver of spiraling healthcare costs. And of course, employers bear much of that financial burden. Our members want malpractice reform. We see Georgia's effort to lead the way as nationally important. Today, business owners agree that the cost of healthcare is out of control, and something must be done. For the sake of the economy, the private sector and its employees, you really don't have to look any further than the price of health insurance premiums. They have shot up nearly 100% between 2002 and 2012, according to the Christian Science Monitor. That's a jaw-dropping price hike of more than $7,000 extra for each employee with family coverage. Perhaps you've heard that wages just barely kept pace with inflation over the last decade. Now that you know the rest of the story, from 2002 to 2013, job creators paid $7,000 more for their workers in health premiums rather than wage increases. Health insurance hyperinflation literally ate up the raises and take-home pay of the middle class over the last 10 years. If you wanted to cripple job creation and hide the evidence, you would be hard-pressed to devise a more sinister plot than this one. Many CEOs are telling us that the problem with the new national healthcare law is not what it tried to do, but what it failed to do, which is to reduce costs. For business owners, healthcare is a significant cost center, and as we move into compliance with the new federal law, future healthcare costs are unpredictable. And of course, when this kind of uncertainty is prevalent, business owners don't invest. Job creation stalls. In part, uncertainty is why the United States has been hovering above 7% unemployment for a year, and our labor participation rate is at lowest levels not seen since the days of President Jimmy Carter. In fact, the new healthcare law does precious little to control costs, and it does absolutely nothing about medical malpractice. So doctors will still practice defensive medicine, which some say are as much as 25% of healthcare costs in this nation. And like today, the vast majority of insured patients will never receive fair compensation. Medical liability reform affects everyone, including employers. Not addressing the issue will cost Americans dearly, particularly doctors and patients. Preserving the status quo only protects trial lawyers and malpractice insurers. But we've seen this before in history. Until the 20th century, the only recourse for American employees injured on the job was to sue their employer, prove negligence, and recover costs. Many employees lost in court. Most could not afford to sue. Many were left jobless and disabled without legal recourse. In the rare case when an employee prevailed, the resulting awards were often so inflated the employer would go out of business. The system was unfair and unjust. As a result, from 1910 to 1920, many states passed worker compensation laws based on those enacted in European countries during the Industrial Revolution. The workers' compensation system is really quite simple. To protect themselves from lawsuits, employers purchase workers' compensation insurance, which provides compensation to employees who have suffered an injury at work, and in return, injured workers give up their right to sue their employer. The reform was a grand bargain between employees and the employers. By any measure, it's a huge success, and there's a reason why corporate America got behind it. The cost of litigation and the cost of compensating injured workers was out of control. Something had to be done then too. In 1920, Georgia adopted a workers' compensation system, which provided injured workers with income and medical benefits. Today, workers' compensation is the exclusive remedy for recovery in Georgia for work-related injury, illness, or death. Similar laws govern compensation in almost every state of the Union, but it's not a European idea as we are led to believe. In fact, a law established in Georgia in 1855 also inspired future American workers' compensation measures. Called the Employer Liability Act, the landmark law provided injured employees the right to seek compensation for their injuries through negligence lawsuits against their employers. 100 years ago, workers and employers came together and comprised to create a compensation system for injured workers that's working well today. History tells us that the most vocal opponents to workers' compensation reform then were lawyers and insurers. They were soundly defeated in every state. We know history has a way of repeating itself. Today, doctors and patients want medical malpractice reform and are ready for a new grand bargain. The business community also wants it. The lawyers and insurers are lobbying against it. And just like in 1855 and in 1920, Georgia stands on the cusp of leading the nation into landmark reform. In fact, the most important reason for fundamental malpractice reform is the patients. Most are private sector employees. Many are the heart and soul of the business. We need to pass State Senate Bill 141 for them most of all, giving them the justice and fairness they deserve, and in the end, better and more affordable health care for all of us. Today, the question you face is abundantly clear. Is the Georgia General Assembly ready to stand up against special interests and lead the way once again? Thank you very much, and I'm happy to answer any questions at this time.